All right, we're back. Our first panel today deals with the most pressing issue of our time, not to mention the reason we're having a virtual event, COVID-19. Not an exaggeration to say that this has impacted everything on a global basis, and that includes the world of securities enforcement and litigation and the SEC. And this panel is going to break down how it's affecting companies and the lawyers and other professionals who are advising them. And let's start the introductions with our moderator, Lou Mejia. Lou's a partner at Perkins Coie. As many of you know, Lou also served for a decade at the SEC, where he was its chief litigation counsel and actually led the agency's Enron litigation and assisted investors recovering more than $400 million. Really looking forward to the discussion you'll be leading of the COVID-19 impact. Lou, welcome.
Great to see you, Bruce.
Next up, David Kornblau, a partner at Covington and Burling, who chairs the firm's Securities Enforcement Practice Group. Like Lou, David spent 10 years in the SEC's Division of Enforcement, including as its chief litigation counsel. His experience goes well beyond that, though, as he was also the head of global regulatory affairs at Merrill Lynch, where he oversaw the firm's response to all regulatory and law enforcement investigations. So glad David's here to help kick things off. Welcome, David.
Good morning. Hi, Bruce. Hi, everyone.
Next, we have Carolyn Welshhans, who is the SEC staff member on this panel. Carolyn is an associate director in the Division of Enforcement. She joined the SEC in 2007 and has a great combination of experience, having served in both the market abuse unit and the cyber unit. We're really interested in hearing from Carolyn and the SEC on this topic, and really grateful she's joining us. Welcome, Carolyn.
Thanks, Bruce.
Finally, we have Dr. Jennifer Marietta-Westberg, who is a principal at the consulting firm Cornerstone Research. And Jennifer brings the unique analytical perspective of a PhD in finance, but combined with the fact that she worked for 10 years at the SEC. She was deputy chief economist and deputy director of the Division of Economic and Risk Analysis. So Jennifer, can't wait to hear your insights on this as well. And welcome, Jennifer.
Great. Thank you, Bruce.
All right, Lou, let me turn it back to you. Take it away. Thank you.
Great. Thank you, Bruce. It's great to be here virtual. I'm sure that by this time, by the time of the next program, we'll all be together again live. Carolyn, I wanted to kind of start things off. Everyone wants to hear from the SEC. And in March, I know the SEC formed a steering committee to coordinate the division's response to COVID-19. And can you tell us a little bit about the work of that committee?
Sure. And before I get started, I'm going to kick it off with some words that everybody's going to hear quite a lot today, and that's that the views I express today are my own and are not necessarily the views of the commission, the commissioners, or the commission staff. But yeah, Lou, turning to your question, in March, the division very early on formed what we refer to as the Coronavirus Steering Committee. It's comprised of over 24 people throughout the home office and regions. It includes senior officers, staff attorneys, accountants, specialists, analysts, and the mandate really, is several-fold to proactively identify potential areas of misconduct. That's obviously the most important, but obviously also to coordinate both internally and externally to make sure that we are facilitating that coordination and facilitating the investigations that have been opened around the country, because the investigations have been run out of the regions and the home office. They have not been run exclusively by the steering committee, as well as to make sure that we're being really thoughtful and appropriate in terms of our use of resources, and that we're being consistent. As I mentioned, there's a lot of internal coordination. I'm sure people have noticed, in addition to statements by the then co-directors of enforcement, there's also been statements and guidance from the chairman, from the Division of Corporation Finance, our Office of Chief Accountant, OC, many others. And we've worked closely with our internal partners as well as various agencies to coordinate make sure that we're helping identify what are those areas of the market we should be looking at given the volatility and the need to protect investors.
Great. And Jennifer, I know that you have been looking at some of these issues in your role on the Commission's Investment Advisory Committee. Do you have some thoughts you can share on your work?
Yes, so the Commission has a few different advisory committees that are made up of various market participants. Some of the members of the committees have held positions at the SEC before, but not all of them. And for the Investor Advisory Committee, Chair Clayton in the spring quickly convened 2 ad hoc meetings of the committee. The idea was to hear from the committee members in their roles as to what were disclosure disruptions potentially that they were seeing, market platform disruptions, and really just to share intelligence about what was happening out in the marketplace.
Great. And I know it seems early, but not too early, but the Enforcement Division has already brought a number of cases relating to COVID. And Carolyn, I'm wondering if you could just give us a sense. I think there's at least 6 and counting. They're all fraud cases, I believe. But if you could give us a sense of what you're seeing in those actions, and what are the key cases there, and what are you seeing in terms of the misconduct?
Sure, I agree. I think that the speed with which those cases have been brought is a real testament to the dedication of the enforcement staff who worked very quickly to bring these fraud actions and try to protect the investors that were harmed in the immediate actions, but also to get the word out, which I think has had a deterrent effect. We have seen a slowdown in some of these actions, and I think that's because hopefully fraudsters realize that the SEC is paying attention. So the 2 main areas of those 6 fraud actions, they really kind of fall down into market manipulation and also just kind of blatant false misrepresentations, misleading statements. When we have areas or time periods of great market volatility and also the opportunity for market moving announcements, you can have those sorts of frauds. We've certainly seen them in prior times of market disruption. So, these fraud actions have included, examples where you have companies and sometimes executives at those companies issuing false and misleading statements, claiming that they have access to N95 masks, treatments, vaccines, all of the sorts of things that people are really paying attention to and are very focused on, and so therefore have the opportunity to move the market. In some of these actions, we've also seen they go hand in hand with market manipulation. So touting pump and dumps in at least one situation, false statements in an investor forum, to try to create interest in the company at the same time that an individual was selling shares without disclosing when he had made those posts that that's what he was going to do. So that's the sort of activity that's kind of comprised the heart of those 6 fraud actions that you referenced.
Okay. David, I know you've been avidly following this area and wondering if you had some observations on this.
More of a question for Carolyn. When I look at those actions that have been filed, at least according to the allegations, that they definitely fall on the scammier end of the range for SEC enforcement actions. And I'm wondering, as you look at the pipeline, which of course the rest of us don't see, do you foresee any enforcement actions related to COVID-19 that are more towards the other end, might involve, say, negligence rather than blatant fraud, or material omissions rather than just sort of blatant false statements? Just curious.
Yeah, no, I think that's a good question. And what we're trying to do is apply the lessons that we've learned from other market disruptions, whether, it was the time period after 9/11 or the financial crisis. And so we're looking at whether there could be potential financial statement or issuer disclosure fraud, which, as you've noted, could potentially rise to the level of negligence as opposed to scienter-based fraud. And so I think there are a couple of questions that are natural to try to ask when you're looking into those sorts of issues. And the first is, do the current financial conditions in the market, the current economic conditions, reveal a pre-existing issue at a company that should have been disclosed previously, but is just now coming to light? I think you also have the question of, is a company's disclosures now, are those disclosures in line with industry peers? And then finally, is there something about the company's current financial condition that warrants a disclosure that either we're not seeing or the disclosure we do see is not in line with those current financial conditions? So I think that's one bucket of things that I think would naturally be on the SEC's mind. Another is, taking a look at regulated entities, broker-dealers, investment advisors, investment companies, for failures to, for example, honor redemption requests. Does that indicate that there's an undisclosed issue? Also looking into questions of insider trading, because I'm sure we're going to get to that later, but the current, financial conditions potentially create additional opportunities for insider trading, because there certainly is a lot of material non-public information related to the pandemic that people are very interested in. Well,
I guess since we're on TV, the short answer is stay tuned, more to come.
Stay tuned. Yep.
Carolyn, I know that, there's a lot of companies out there touting various products and therapies and different types of masks and claiming to have capabilities to do different things. And the SEC has said that they're monitoring this and monitoring trading activity. And how in practical terms is the SEC doing that?
It's in a couple of different respects. We source our investigations from a lot of different places, and a time of market disruption like this one is no different. In terms of some of those sources, we get tips and complaints and referrals from the public, whistleblower complaints, referrals from FINRA and other self-regulatory organizations, as well as criminal authorities and state regulators. We pay a lot of attention to the news, just like everybody else. But in addition, as our former co-director, Steve Pika, noted, we're trying to take a very systematic approach as well to looking at, for example, the industries that have been very impacted, looking at their public filings, looking at the trading around those companies to see if we see anything suspicious. So we definitely have a very proactive bent to what we do. We're utilizing the expertise of the specialists and the analysts that we have in-house, the accountants, some of the specialized units, to try to really think about where could there be potential misconduct, what's the data that either we have or can pretty easily go get, and what are the questions we can ask of that data to see if we can identify problems, hopefully before they become bigger issues.
Okay. Looks like David has a question for you.
Yeah, I was wondering too, obviously the commission and the different divisions has very deep expertise on really all matters involving the financial markets. But I would think some of these issues involve effectiveness, safety of COVID-related products, services, sort of more medically focused issues. Where would the staff turn for expertise on those kinds of questions?
Sure. And so I'll just, note that this time is not unique in terms of oftentimes, as you noted, we are dealing with, potential disclosure issues that are very technical and that might have to do with a particular industry that has a different primary regulator, whether that's the FDA or Health and Human Services or, DHS, lots of different things. We, through the Coronavirus Steering Committee, have helped facilitate some of the discussions with those sorts of agencies, how to have that sort of conversation, how to have that information flow, and then, individual investigations, depending on their particular facts and circumstances, obviously, are asking more specific questions. But, if we need to determine, for example, and this, again, it's not unique to the pandemic, if someone is claiming, that they have a product that's been approved by a particular agency, or they have a contract with a particular agency, a very natural question and one we should be asking is that accurate? And go to who that other supposed partner is and get their take on things.
One of the interesting things that I've seen in the enforcement in this area is sometimes enforcement will do an emergency TRO or try and do an asset freeze. We've seen a lot of use of another technique, which is trading suspensions, which seem to be like a pretty useful tool in the enforcement arsenal. And I know, Jennifer, you have some thoughts on that. Maybe we could turn to Jennifer first for your thoughts on that.
Yes. So if you look at the trading suspensions, I think there have been more than about 32 in total. The bulk of those really came in April and May, although we have still seen a couple in the last month or so. And many of the firms that were subject to the trading suspensions also subsequently have been the subject of an SEC enforcement action. But curious to get Carolyn's thoughts here as well.
Yeah, and I think that's a really good point. You're right. I think by my count, it's close to 24 of the trading suspensions were in March, April, and May, which again I think reflect the really quick work by the staff. Trading suspensions are instituted due to a concern about the accuracy or the adequacy of information in the market. They don't necessarily mean there has been fraud, but it's a very natural question. And as you noted, there have been several fraud actions brought following trading suspensions. For example, the Praxin matter, which I think was the first fraud action filed related to COVID-19, where the SEC charged the company and its CEO for making false and misleading statements in as recently as August. Both the company and the CEO agreed to a settlement with the SEC on that action, in addition to fraud injunctions, paying penalties, and the CEO agreed to an officer and director bar. So again, I think that reflects the fact that there's quick work when there's an indication of potential issues related to the information in the market, to put in the trading suspension, put in that halt, but then go look and see, are there further issues that warrant a fraud action to bring those additional protections to the market and to investors.
Great. And actually see that we have some questions for the panel, which let's try and get to some of the questions before we move on. The first question comes from Jesse M. in Arizona. Lou, this is the best panel I've ever seen. Can you talk all day? Mom,
I like that question.
Mom, I'll call you when we're done with the program, but others have to take their turn, okay? Second question comes from Michael X. Hi there. I'm wondering if there are any SEC enforcement investigations for COVID-19 related insider trading. So
I obviously can't talk about any ongoing investigations. I can speak just more generally at the fact that insider trading is, one of the areas of concern I noted that we've identified. We've seen it in other prior market disruptions. The then co-directors, Stephanie Avakian and Steve Pekin, issued a statement pretty early in the pandemic calling attention to this potential issue, noting that companies are in possession of probably more and different types of material non-public information than they might have been in the past. Those can be companies directly working on or tied to efforts to try to respond to the pandemic, whether because their products or services are related to that response, but also just, as we saw the market go up and down, people are very focused on how the pandemic is affecting companies and their earnings. So there's a lot of attention to those market moving announcements. The number of people who are involved in handling this material non-public information might be greater or might be different than companies have seen in the past. So important for companies to keep that in mind, as well as their executives, their consultants, other outside professionals who might be coming into contact with that material non-public information, because I think it's not a surprise, to think that risk could be there.
Okay. We also have another question from Chris, who asks, the SEC reports on COVID-related actions, but doesn't provide a strict definition of what makes these actions different or what sets them apart from regular enforcement actions. So I guess the question is, what do you consider COVID-related?
Sure, and again, this is definitely a place where I'm answering just for myself, because I'm not in charge of those sorts of metrics. But I mean, I think like the 6 fraud actions that the panelists have referenced, I think those are very clearly related to COVID-19. They all involved companies that were making claims or manipulation involving supposed statements about treatment, services, products related to COVID-19. And so, I think that's really where we're focused. Are people trying to take advantage of this, crazy environment that we're all living through and trying to deal with by, hyping, touting, trading on, doing something that ties back to a response to the pandemic. We haven't seen cases along this line, but something where a company, as we talked about earlier, might have disclosure issues because of either what they're experiencing now in their industry or what they might have not disclosed before, but now the conditions have revealed. That could be considered something as well. But certainly what we've seen come out so far, I think, is very squarely tied to COVID-19.
Right. I could see a company that has been impacted by COVID and then engages in some misconduct to hide the fact that, hide some other misconduct, that could be COVID related. But just because a business makes a misrepresentation because it's suffering the fallout from COVID, that would clearly not be a COVID-related action, as I understand it.
Yeah, I think it would depend on the facts and circumstances. But yeah, I mean, I think there's kind of a spectrum. And what we've seen so far, I think, is very clearly tied to statements about products, services, trying to manipulate trading around those sorts of things.
Right. So we heard a lot at SEC Speaks about how COVID has impacted the agency and just carrying out its day-to-day activities, getting documents, taking testimony, Wells meetings, things like that. And I think they covered that. For those of you who were at SEC Speaks, I thought they covered it pretty well. One of the things I wanted to focus on, though, for a minute is Wells meetings, which are occurring remotely. And I wanted to get David's thoughts first about, to me, there's a real downside to having a remote Wells meetings, that those, to me at least, should be done in person. But David, I wanted to get your perspective and then Carolyn's.
Sure. Yeah. I mean, you always would prefer in person for that sort of interaction because, you know, you're trying to get it. There's what people say, and then there's also the body language, the facial expressions, the tone, and then also just sort of credibility. You want to be able to make your case as effectively and directly as you can. That said, you know, what we're doing now, video, the technology, it's still got lots of kinks in it, as we know, but it's not bad. I mean, you can communicate pretty effectively using the technology if it works on that given day. You can show documents, key emails, highlights, all the fun stuff that we like to do. So that doesn't seem so significant to me. I will say, though, I've done a couple of presentations, and it was earlier on when people were still really scrambling and trying to figure things out. And I remember on the defense side, we were thinking, oh yeah, we're like, do we want to do this video? Yeah, we definitely do. We'd like to sort of get a feel for where the staff is and get our best sense of it. So we said, yeah, we'd really like to do this with video. We did that. And then, like, I think 2 out of the 3 staff members dialed in and we didn't see them. So, well, we were there on video. They didn't see us and we didn't see them. So, you know, there's that was less than ideal.
Okay. Carolyn, I think we've seen.
Oh, sorry, go ahead, Lou.
Yeah, I think we've seen, you know, to me, and I think I'm also, I was glad to hear Stephanie Avakian make the same comment that for Wells meetings in general, but more particularly now since we're remote, that defense counsel, it behooves us to be very surgical and targeted in those meetings, not to talk about the whole landscape, but maybe pick, you know, the most important issue that's on the table. Maybe it's materiality, maybe it's intent, could even be relief. But it'd be great to hear your thoughts on how people should be approaching Wells meetings in this remote phase.
Sure, I can take that. I wasn't sure if you were asking David because I'd be interested in his thoughts on that too. But yeah, I absolutely agree with that, and I agree with David said too. Like it, you know, I think we'd all prefer, given our druthers, to be able to be in rooms with each other again. That being said, I think that the interest in moving investigations forward and hearing from defense counsel so we can make those decisions of whether to charge, what to charge, and as I said, like not to charge in some cases is very important. And I think that the as we've all gotten more used to the technology, even though my video keeps cutting in and out this morning, I think that has improved. I think there is something to be said for the AV probably works a little better when defense counsel can control it as opposed to being in one of our offices and relying on us to try to hook up their computer to our AV system. And I do think that people are very focused and engaged in these presentations. It is really helpful to see if there are particular emails or documents and the highlights of what counsel thinks we should really be focused on. I agree with what Stephanie said, and I think that was true pre-pandemic, and to the extent that it's focused people more during the pandemic, I think that's great. That I think those meetings are most effective when instead of coming in and just saying everything and, you know, throwing it at the wall and seeing what sticks, that we hear what counsel thinks are the strongest arguments so we can really focus discussion around those. Or if there's a settlement to be had, what is the bottom line? What are the deal breaker terms? So that we really can use those discussions most effectively and really get to the heart of the issues.
Great. Jennifer, let's turn to shareholder litigation and the ramifications from the pandemic. Can you give us a sense of how COVID has impacted securities class actions?
Yes. So as of now, there have only been a handful of specific actions related to COVID. So we've not seen a huge wave of cases. The normal core securities cases are still being filed. In the first half of the year, based on what we've tracked, historically, filings have been high, although not as high as the last half of 2019. But the types of COVID-related cases that were filed initially are what you would expect. Basically, those industries that would be affected by an exogenous event like a pandemic, so tourism, cruise lines. And I think for issues relevant to all securities cases, those issues will still be manifest here in relation to the spring 2020 events. So if you're analyzing, say, market efficiency, what are you going to do with the spring period when there was a lot of market turmoil, price swings? So I think legitimate questions can be raised about whether the market was efficient during that time. And as we discussed earlier, not only were there price swings, but certain stocks had trading suspensions against them as well. And other types of analysis that you would try to engage in for these cases, whether there was potential confounding news effects out there, that's certainly a possibility. Stocks may have been reacting to news coming out from monetary or fiscal policy developments rather than company fundamentals. And I won't get into technical details of regression analyses, but the typical types of statistical analyses that one would conduct over this period likely is a structural break if you're looking pre and during the pandemic. So all of these will bring important issues to mind when conducting analyses for these cases.
Right. And I think we're entering into an interesting phase now, because now we have therapies that are being touted. Some are being approved. There are vaccines on the horizon. So I anticipate that there will be a phase where the therapies are being used and the vaccines come out. And so as these medical treatments advance and are being used and companies are making claims about these products, what do you anticipate in terms of the private shareholder actions?
Well, I think we'll have to see how those vaccines and developments progress. So some suits have been filed about vaccine candidates in development and alleged misrepresentations about their promise. But if certain treatments and vaccines do begin to work and start to hit the market, later there could potentially be bad news associated with those. If there's any adverse effects, or if the results did not meet expectations, that could lead to stock price drops and lawsuits alleging misrepresentations. And so then obviously you would be potentially seeing filings related to that.
David, I wanted to get your perspective as a litigator. Do you see anything unique about these types of actions relating to the pandemic, whether it's the strict pleading standards or other aspects of litigation? Anything that we should be looking out for?
Probably not unique, I would say. Shareholder actions, there's a lot of sort of defenses you frequently see put forward in them, and I think a lot of them would apply to these cases as well. But there are a couple of points I think that would stand out for a lot of these cases. One would be the question of loss causation. So the SEC in enforcement action doesn't have to prove loss causation, as Carolyn and her colleagues will remind people very frequently. But in the shareholder litigation, it's a key required element. And when you're dealing with periods of extreme market volatility, and we've had some of those, and frankly, we may be entering into more. I mean, I don't have the crystal ball, but it's quite possible. that makes it tough to prove loss causation. Because if the suit is based on a stock drop on a date when there's a broad market move, then it's very hard to prove that the losses were caused by any particular alleged misstatement. And Jennifer and other economists would have a field day, showing that there really is not a good causation proof in that kind of case. So that I think that will be a significant issue. The other one is, I think you're going to see defense counsel arguing that a lot of the alleged misstatements in those cases fit in within the concept of a forward-looking statement. And as the civil litigators know, there's a safe harbor in securities, private securities actions for forward-looking statements in the Private Securities Litigation Reform Act. So I think there's going to be a lot of debate, and it's not always obvious whether a statement is forward-looking or not, but I think that's going to be an area where you see a lot of argument, and you may see some cases dismissed on that basis.
Right. So we have a couple of questions here. The first is from John R.S. Lou, do you know what level of monetary sponsorship for Bruce's program is necessary to get a spot on the Enforcement 40? I don't know the answer to that question. That's probably best directed to Bruce. The next question is from Jacob, and I think this is directed to you, David. He said you made a great point about staff participation in Wells calls, and that, your statement about them being present for these calls, and it could apply to testimony too, where there's no video. And do you think that staff should be obligated to participate by video? Because as you know, staff is often hard to convince of certain things, and you want to see their facial reactions and body language. What do you think?
I mean, obligated is strong, but I would say encouraged, right? I mean, on any given day, we all have our technology issues, but, I think it makes the division look good, and it helps them make better decisions if they get the best quality information and input from defense counsel. And I think in these kinds of meetings, face-to-face is very helpful for that. So I would, if I were, in charge of the enforcement division, I would be encouraging that.
Carolyn, what do you think?
Yeah, I mean, I think, definitely, for example, when it comes to testimony, we think that, the person, the lead staff attorney, should be on video because that's only fair that, the person who's asking the questions can be seen by the person who is going to be answering and their counsel. Sometimes we have many more people than that attend testimony, as most of you know. And given the limitations sometimes of the videos and the buffering, sometimes the people who are not asking the questions may not have their video on purely for purposes of trying to conserve that bandwidth. But I do think if people are speaking in that sort of context, they have been encouraged to have their video on so that people can see that. And I think that David's point, about the Wells meetings are very fair as well, because oftentimes we are in reaction mode in those sorts of meetings and listening mode. But I think helpful to see, particularly, the people that you might be making those arguments to for the first time. The staff may have heard it before, but sometimes other people in the room have not. I think that can be helpful as well.
Great. I think that one of the final areas I wanted to address quickly is the Division of Corporate Finance issued disclosure guidance both in March and in June, giving companies their views on how they should be making disclosures related to the pandemic. And I don't know about people in the audience, but I see a lot of landmines and risks here, given the uncertainty of the virus. But CorpFin has issued this, and I just wanted to get people's reactions to this about, with so much uncertainty, so much risk, how should companies be thinking about their disclosures? And I'll start with David.
Sure. Yeah, I think those points are very well taken, and we've been advising our issuer clients to proceed very cautiously. 10K season is coming up. There's not only uncertainty and risks, but the landscape just changes constantly, right? So forward-looking statements that the chairman has encouraged companies to make forward-looking statements. It's a dangerous area. It's tricky because, even statements made in good faith today, it's so hard to know what's going to happen. From having handled a lot of disclosure, accounting related investigations, a big takeaway I have, which I think applies here, is even though the law is that you assess financial statements, alleged misstatements at the time they were made, it's just the nature of an investigation and an enforcement process that you're looking backwards at prior events, and that gives you the wisdom of hindsight. Maybe the company's performance has not been as what it had hoped to be. Maybe the markets in general have declined. So you have to think about your disclosure today about what it might look like in the rear view mirror if things don't go the way that you hope that they go. And that can cause you to maybe be a little more cautious.
Jennifer, what do you think?
Well, I think that we have seen firms be responsive to the call-outs from Chair Clayton starting on January 31st of this year, along with the Division of Corporation Finance and others, to reference COVID and incorporate it to the extent they can. There was a big jump in February and March of firms referencing COVID in their filings, another big jump in May, as you would expect with earnings season. And by August, 80% of the cumulative filings between January and August had referenced COVID.
Great. So I think we're close to wrapping up. We have one final question, which I think I can answer, and it comes from Myron. Lou, is it true, as Bruce says, and as also posted on the forum website, that, quote, this is the preeminent securities enforcement program in the world? And I can answer that question. Absolutely. This is the best. Enjoy the rest of the panels. Bruce, thank you very much. And thank you, everybody on the panel.
Thank you.
Thank you.
Thank you.
Hey, thanks, Lou. There's a giant bag of cash waiting for you. I appreciate you getting us off to such a great start to the whole panel. Thank you. So our next panel on cybersecurity and cryptocurrency will begin in just a few minutes at 9:20 a.m. Eastern. We'll see you in 5 minutes. Thank you.